Thank you very much for the introduction. I hope you can all hear me very well. I will talk indeed about the interaction between copyright and design law in the European Union. Next slide, please. So, as I mentioned in my previous presentation, we had an public consultation where we asked several questions to the stakeholders, because we also wanted to know how they feel about the fact that very often certain products can be protected both by copyright and they can be protected by design rights. And one of the questions was if they see it as a problem that people actually opt for copyright protection instead of design protection. Because of course copyrights you get automatically, there's nothing you have to do for that, whereas design rights you have to register, not all, unless it's an unregistered design in the EU. But if you want to have a registered design right, which also offers you more protection, then of course you have to file and you have to pay a fee. So we asked them how they feel about the fact that some people prefer to just rely on copyright law, which in some member states actually is quite a nice option because practically anything is protected by copyright law. Actually, the level of requirements they set for copyright protection is rather low. But to our big surprise, actually, if you have a look at the chart that is presented now here on the screen, you will see that most people didn't really were so much bothered by this. Then the other question that we asked was how they feel about the fact that in Europe, designs can be protected both by design law and by copyright laws. Of course, under certain conditions, but in principle, this is possible. And also here, to our surprise, actually, people are not much bothered by that. So actually, these were the results of the public consultation, and of course, something we have to take into account when we draft our the review of our design legislation. Next slide, please. So, as I already mentioned, in Europe it is possible to have protection for certain products, both under design law and copyright law. This is mentioned in the directive and in the design regulation. Of course, there are certain conditions. The protection requirements must be fulfilled, of course, under design law. These were explained by Peter earlier, no? What the requirements are, novelty and an individual character. And for copyright, of course, also there, the requirements under national law for copyright protection must apply. Only in under those circumstances, you will have accumulation or a protection of a particular product for both design law and for copyright law. What is important to mention is that when the directive and the regulation came into force, copyright law was not harmonized yet. So in each member state, the national laws on copyright were quite different actually, and they had different requirements as to the level of originality of the product. So this is something to bear in mind. Next slide, please. So, but things have changed. In the meantime, since the introduction of the directive and the regulation, copyright law has been harmonized by means of a directive, and this directive has been further interpreted by the Court of Justice of the European Union through different decisions of this court. And what has been clarified by the court is that a work is actually something that can be protected under copyright law, must be applied and interpreted uniformly in the European Union, and it has to be an author's individual creation, which must result from free creative choices of the author, and it must reflect the author's personality. So these are actually the requirements for having copyright protection of a particular product. Next slide, please. So one of the first cases that actually was being dealt with by the European Court of Justice was the Vlos case. And actually there the court made clear that there is no exclusion of copyright protection for designs, because what happened is that in a particular member state at that time, that member state wanted to exclude protection for copyright because that particular company that wanted to invoke copyright on a particular product in that member state had not registered design rights. However, such an exclusion is not possible, even if it's limited in time, and this was clarified by the court. So this was actually resulted in a widening of the copyright protection for works of applied art and a possible overlap with design law. Next slide, please. Then another very important decision of the European Court of Justice concerned the Cofemel case. In the Cofemel case was actually about clothing. And there the court decided that only in very limited cases there's a possible overlap of copyright law and design law. Because what must be borne in mind is that actually the two rights have different objectives. So where design right is actually intended to for the design right holder to have a return on investment, and design rights usually design doesn't necessarily have to be a really very super original product. No, it can be a chair, a table, yeah, very basic, commonly used products. Whereas copyright actually has a different purpose. It actually usually is offered only for more artistic or products, and they therefore deserve also a longer term of protection, because design rights are limited in their term of protection and copyrights have a much longer term of protection. And that the reason why they have that is that it offers the right holder of that particular work to exploit the work. Next slide. Another case, important case of the European Court of Justice, where it further explained the notion of work, of copyright, was the Brompton case, which concerned a bicycle, which you can, how do you say this, make smaller by how do you say this, folding it. So it's a kind of foldable bike. And there the question was, is this actually a copyright work? Because, of course, it's to a large extent, its design is restricted actually by its technical function. And that is the fact that you can fold it. And there the court said that, in fact, it can be protected under copyright law. But there, of course, is a condition, and the condition is that the author has reflected his personality in that subject matter as an expression of free and creative choices. Only if the design of the bicycle would be completely dictated by the technical function, only in that case no copyright protection was possible. But usually, of course, you can make you have the freedom to make some small changes to the design of the particular product, which also reflect your personality. And for that reason, there is in principle a possibility for copyright protection in that case. Next slide, please. So that brings me to actually the last slide of my presentation, which is very short. And that is now the question that we have to deal with, no, as legislator. What are we going to do with the provisions that we have in the directive and the regulation that actually say that cumulation is possible, and that we leave it up to the member states to determine the level of originality of the required of a work of art under copyright. So I let you think about that. I think Peter has already given his opinion in his presentation, how he feels about long terms of protection. I want you to think about it as well. We will think about it as well. But it's clear that with the harmonization of the copyright laws in Europe and of clarifications by the court, probably it is questionable whether we should leave the question of the level of originality to the member states. Thank you very much.